so glad that you were able to come over tonight and listen to our special guest. I'm Cori Sherman, the current president of the Salina League of Women Voters. And I'll take this chance to remind everyone that the League is a nonprofit, nonpartisan volunteer organization that has been in place for more than 100 years. And we are encourage people to register to vote and do your civic duty and get out to the ballot boxes. Nonpartisan doesn't mean that we don't take positions on things. We don't support particular candidates or particular parties, but we do have issues that we feel are important to take a stand on. And tonight we will be talking about one of those issues that we do think is very important on our upcoming proposed amendment to the Kansas Constitution. It'll be in the August primary election, and it'll be addressing our current merit-based system for selecting Kansas Supreme Court justices. Tonight, our special guest is Kansas Appeals Court Judge Karen Arnold-Burger, and she will be explaining all of this, and then she will be answering questions after she gives the presentation. And so everyone is encouraged to come up to the microphone at that point in turn and ask very succinct questions that we can all learn from. I just want to encourage everyone to be registered and ready to vote in August. We have our usual table over there set up with some registered paper forms you can fill in, and then we also have these cards with the QR codes that you can use.
Do you have any friends?
Yeah, I suspect all of you are registered right now, but if you have friends, please take those materials. And also, the Kansas United for Impartial Courts has provided us with some take-home handouts you're welcome to grab, also from that table. And further ado, welcome.
Thank you very much. Thank you for inviting me. I'm going to tell you both sides of this issue. I'm not here, I will tell you personally how I'm going to vote, but I want to make sure you hear both sides of this. This is the amendment. It's a little shortened. It's actually a little longer than this, but this is the basics. Amend the Constitution, provide the direct election of Kansas Supreme Court judges, establish 6-year terms. They already have 6-year terms, so that's not a change, and abolish the Supreme Court nominating commission. I told you I was worried all the way in here that I was going to start talking. A yes vote allows the election of Supreme Court judges, and a no vote keeps the current system in place. Now, in order to understand why about this change and what it means, I really think it's important to go back in time and have a little civics primer here about what courts are and what they're meant to do and how they were set up by our founding fathers. So, did it again? Maybe I have to start over real quick. Yeah, there we go. So, in the beginning, when we were the colonies, in our Declaration of Independence, it says, "He, King George III, has made judges dependent on his will alone for the tenure of their office and the amount and payment of their salaries." And they thought that was awful, because they didn't think that the king should control how judges rule. And if the judge did not rule the way the king wanted, the judge fired them, or the king fired them and got another judge. So, in our very Declaration of Independence, we spoke against the politicizing of judicial positions. And judges were all selected by the king. There was really nowhere in the world at that time that had any concept of election of judges. Most of the places they were appointed by the king, But in our democracy, the decision was set up primarily by Alexander Hamilton, and we'll talk about him in a minute, to make our judicial positions different. Okay, so you all learned this in high school, right? We have 3 branches of government. The legislative branch makes the law, the executive branch enforces the law, and the judicial branch interprets the law. And all are co-equal branches, and we don't want one to overrule the other. Pardon?
Correct.
Yeah. So as James Madison said, the accumulation of all powers, legislative, executive, and judiciary in the same hands, may justly be pronounced the very definition of tyranny. So this whole point of 3 branches of government is central to our democracy. And there are checks and balances throughout. And the best example I can give of a check and balance is what happened a couple years ago. The Kansas Supreme Court made a decision that, unlike the United States Constitution, the Kansas Constitution provided a right to abortion. And that's very simplistic. But the legislature felt that that was not the will of the people. That's not what the people wanted. And so they went through the process of checks and balances and put forth a constitutional amendment to amend the Constitution. And that's what happens. If there's a disagreement with a court ruling, you can either change the law to make the law constitutional, or you can change the Constitution to comply with whatever you think the rule should be, if you can get the majority of people to support you in that quest. So there are checks and balances on each branch. The legislative branch usually funds the courts, so there's some money there. But this whole system is extremely important to making our system work. And we've all heard of Alexander Hamilton. He has his own musical that I've seen because it's my granddaughter's favorite at least 100 times. So limitations on legislative authority can be preserved and practiced no other way than through the mediums of courts of justice, whose duty it must be to declare all acts contrary to the constitutional way. Without this, all the reservations of particular rights or privileges would amount to nothing. And let me drill down on that a little more. So the First Amendment says, Congress shall make no law abridging the freedom of speech. All right, pretty simple, everybody's heard that. It doesn't say that people have the right to freedom of speech, it says Congress can't make any law abridging the freedom of speech. There are limits on congressional power. So let's say a statute was adopted by the legislature that said you can't get a parade permit for a gay rights event or a Ku Klux Klan permit. And the argument is that that impinges on a person's right to free speech because you are giving some people a right that you're not giving others, and you're doing it based on the content of the speech, and that's in violation of the Constitution. Now, if we didn't have courts to review that and decide that that was unconstitutional, there are no limits on legislative power. None. So if if the legislature says you can't get a parade permit, and there's no court to review that, or a court that's in the pocket of the legislature, you don't really have constitutional review. Okay, there's no liberty if the power of judging not be separated from the legislative and executive powers. Liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. The judiciary is in continual jeopardy of being overpowered, awed, or influenced by the other 2 branches. And let me give you just a couple examples in history. During the New Deal, Franklin Roosevelt wanted to increase the members of the Supreme Court because he felt that they were not upholding a lot of this New Deal legislation. And so he said, well, I'll fix that. I'll just put more people on that are in alliance with me, and they'll decide my way. Well, the legislature put the kibosh on that and didn't allow that to happen. Another great example is when Brown versus Board came out, the Southern senators entered what's called the Southern Manifesto that basically said blood will flow in the streets of Richmond if black children are allowed to go to school with white children. And they indicated that they were not going to comply, and sure enough, in Arkansas, they did not comply. And our favorite son, Dwight Eisenhower, went on television and said, I don't care if you agree with the Supreme Court decision or not. That is the law of the land, and I will President of the United States, and I will enforce that law. So you have the president step in to assist the judicial branch to make sure that these three branches were in fact independent. So, how did they decide they wanted to do this then? How did they want to appoint judges in this new republic? And they decided two steps. One, Senate confirmation. Now, at that time, the Senate was not popularly elected. Senators, each state legislature selected what senator was going to go to Washington. They weren't popularly elected at that time. And the idea of having Senate confirmation was that a president couldn't just get an unqualified crony into the position, that they'd be able to have some review of this person and their qualifications. Another great example of that working the way it should was back when George Bush tried to appoint Harriet Miers. I don't know if you all remember this, many of you were probably too young, but Harriet Miers was his, I think, chief legal counsel, had very little, if any, experience that would qualify her for the United States Supreme Court, and the Senate voted down that person. The other thing they did was lifetime appointment. And why did they do lifetime appointment? To protect judges from the political winds of time. You don't want judges deciding cases based on what the most politically expedient thing at the time is. You want them deciding cases based on the rule of law. So these were the two criteria: Senate confirmation, lifetime appointment. So what do our courts do? Well, they resolve disputes through a legal process, they interpret and apply the law, and they determine if the law is unconstitutional. They only handle cases brought before them. So if a case isn't brought before them, that case isn't decided. It requires litigants or the government or individuals to bring cases before the court to claim that the law isn't being interpreted correctly, in resolving this dispute, or this particular law is unconstitutional. And what are the difference, and what is the difference that our founders said between elected officials and judges? Elected officials, decisions are based on the needs and the desires of their constituents or voters, their own beliefs, or their own political agenda. We know that when we elect them. That's the whole point of electing officials. Judges, on the other hand, are to be separated from that, so that their decisions will be based only on the facts of the case, the law of the case, a fair and impartial analysis free from influence by politics, special interest groups, money, public opinion, or their own personal beliefs. And I think we can all agree that if the Supreme Court was simply going by what the will of the majority of people in the United States was, we would have never had Brown versus Board of Education. That took a courageous court to take a position based on the rule of law, not based on their personal beliefs or the beliefs of the majority. All right, so that was the way it was, and most states or colonies that entered the Union had a similar process. They had a governor that put forward a name, the Senate had to confirm them, and then they were appointed for life. That was the system of most places. And then from 1828 to 1868, we had the rise of Jacksonian democracy. And this is when we first started seeing the United States election of judges. And multiple parties emerged at that time. All white males could vote, including non-property owners. That was new. Before that, you had to be a property owner in order to vote, although you didn't have to be a citizen. There was a patronage and spoil system that was encouraged and valued. Jackson is the one that said, to the victor goes the spoils. So if you win, you get everything. So populism rises, there's a strong executive branch, and they started electing judges Why? So that to the victors would go the spoils, the judges would do things the way they wanted. The Kansas Bar Association started speaking out about this, as did many bar associations across the country in 1897, was their first statement. And they said, as the tenor of office and the mode of selecting the judges of state courts, we have in late years easily yielded to the persuasions and devices of partisans who have cunningly planned to obtain their own selfish ends, who have been led by the blind hope of reform to try mere experimental change. The facility with which judges were first made elective in the last generation, without due consideration, is one of the most striking and significant facts in our political history. And that's because when Kansas entered the Union in 1861, we elected our Supreme Court judges. Okay? We also had in 1906 Roscoe Pound, probably the leading legal scholar of his time, putting courts into politics and compelling judges to become politicians in many jurisdictions has almost destroyed the traditional respect for the bench. Again, William Howard Taft, who ended up being on the Supreme Court, said it's disgraceful to see men campaigning for the state Supreme Court on the ground that their decisions would have give a particular class favor. It was so shocking and so out of keeping with the fixedness of moral principles, he said, that it ought to be condemned. So these huge legal scholars were going all over the country saying this is a bad idea. So then, starting in 1890 to 1920, we had the Progressive era. And we had Teddy Roosevelt and his merit selection systems in government to eliminate corruption, move to civil service or merit systems of appointment, was to make government more efficient, did away with secret ballots, referendums, and recalls to fight the and allowed for referendums and recalls to fight the overwhelming power of political machines. And at that point, we started to have the popular election of senators with the 17th Amendment. So these were considered the three progressive era presidents. So what happened? In Kansas City, we had a guy named Pendergast that was controlling everything, including the judges, including the police. And there was a great, and you see here organized crime, gambling rackets, there was a great fight against that. So Missouri was the first one to develop what we call the traditional merit selection plan. And it's often referred to as the Missouri Plan. That started in 1940, and that's when states started to move to this merit selection process. So they kind of swept the country at that point. They were based on a permanent, nonpartisan commission made up of lawyers and non-lawyers, and they would forward the names of 3 to 5 applicants to the governor who must select for the list. And that's exactly the system we have in Kansas now. And states around the country utilize one of these 3 models. They either have elections, which either are partisan or nonpartisan, appointments with different models in different states, whether there's Senate approval or some other kind of commission, hybrid models where you have merit selection and retention using a nominating commission to review the candidates, followed by appointment and retention. And the benefit of having a nominating commission is that anyone can apply for the position. It's not based on your political background or how much you contributed to a particular campaign. Anyone can apply. And this nonpartisan commission is making a decision based on merit as to who the best 3 to 5 candidates are for the position. So, as I said, prior to 1957, all judges were elected. Kansas Bar Association started calling for reform. And then we had what is famously been called the Kansas Triple Play. In this case, we had Fred Hall, this guy right here, who was governor. And at that time, he could only be governor for 2 years. He was a Republican, but he wasn't well liked by anybody. He became a lame duck. He only had a 2-year term. His best friend was William Smith, who was the elected Chief Justice of the Kansas Supreme Court. His lieutenant governor was John McCush. And so they worked out a deal. William Smith had been sick. Fred Hall resigned from office. John McCush became governor. William Smith resigned from the Supreme Court, and John McCush appointed Fred Hall to the Supreme Court. Many people viewed that as pretty blatant corruption, made all the newspapers. Oh, here, I get a little. I was clever 10 years ago when I did this. Okay, so people responded. I thought I was pretty good title attorney. This is the greatest shift of titles I've ever seen. It's a short time, the sucker shift, the thing Notre Dame used in football. A brazen raw deal for Kansas justice, believe it or not. And his move was an offense against the whole idea of an independent judiciary. And so, the Kansas people voted for a constitutional amendment to change the selection of judges to a nominating commission and a merit selection process. So the nominating commission, you've all got a piece of paper that tells you how this nominating commission is set up. But it's made up of lawyers and non-lawyers. Now, there's often a word said that the Kansas Bar Association controls who's members of the nominating commission, and that's simply not true. The Kansas Bar Association is a voluntary bar. It doesn't make up every lawyer in the state of Kansas. And the way the lawyers on the nominating commission are picked is they run in congressional districts and they are voted on by all the attorneys in that district. Whether they're a member of the Bar Association or not has nothing to do with it. And then the governor makes an appointment so that there's an equal number of attorneys and lawyers and non-lawyers on the commission. And then the chair of the commission is a lawyer, voted for by all the lawyers in the state. So one criticism that we'll talk about in a minute is that this is elitist, that the nominating commission as exists is geared toward lawyers, and lawyers have a major payment. And we'll talk about that in a minute. Okay, so Kansas Judicial Branch, we have 7 justices in the Supreme Court, 14 Courts of Appeal judges, that's where I am, 31 judicial districts and 105 counties, and then we have municipal courts. So the selection of the Supreme Court, as I said, 4 laypersons selected by the governor, 1 from each of 4 congressional districts, and they're staggered terms. So the governor may have an appointment for a 4-year term for somebody, but then another governor may come in, so it's not necessarily all the lay people are all appointed by that particular governor. There's a mix. 4 lawyers, 1 from each of the congressional districts elected by the lawyers in their district, and 1 chairperson, a lawyer elected by lawyers statewide. Our district courts are torn. When we had court unification, there was a question, were many district courts around the country that elected their judges, and they liked doing that. So about 50% of our district courts in the state are merit selected, where the names are sent to the governor by a nominating commission, and that's how it's done here in Salina County. And then about 50% are bipartisan elections throughout the state. And this is a map of where it is. The white districts, which are generally your much more rural districts, except for Sedgwick County and Wyandotte County, both have elected judges. This was established in the 1970s when there was court unification, and many of these districts have tried to change from either elected to appointed or appointed to elected. None of them have ever succeeded. They kept with the same thing that they started with. Okay, I already told you, Salina County. And they'll be at the very end of the ballot. This is what your ballot looks like in Salina County. You'll have the Supreme Court justices. Shall Eric Rosen, Topeka, be retained in office, yes or no? So Justice Rosen isn't running against somebody else. These merit selection systems also rely on a retention. So it's not lifetime appointment. The judge does have to come up for retention of the voters. So if there was a massive movement against one of the judges, they could simply not retain them. Now, one of the things that people, the opposition will tell you is, well, that's never happened, or it's happened only one time in history. And it hasn't happened very often. And I would say that's because there's a very robust judicial ethics program that sometimes will kick judges out of office based on ethics violations. And most of the time, if you have a judge that's getting themselves in trouble and they're on the front page of the paper every day, they're not going to run. So right now, that's all you're doing is voting on whether they should be retained or not. District judges are every 4 years. Court of Appeals judges are every 4 years, and Supreme Court justices are every 7 years, taking up the retention. Here's what a ballot would look like in an elected district. You would have the judge and people running against each other, like in Sedgwick County. This is Sedgwick County where they run as Republicans or Democrats. But then you also have a merit retention ballot where those from the Supreme Court were appeals. So, we have this proposed amendment to the Kansas Constitution. It's on the August 4th primary ballot. So the first question is, why the primary? Well, turnout dynamics. And these are not secrets. I'm not saying positions that aren't well known and have been well stated. Primary elections generally have lower and more partisan turnout than general elections, proportionally more Republican voters, and it reduces the participation in independents. So opponents say they think, people who say vote no for the amendment say they think voters should have a bigger role in the selection process. I find it ironic that we've chosen to place this constitutional amendment on a ballot of low turnout elections. And I just tried to pull what people have said in the press about these. The people that are vote yes on the amendment say this is a valid discretionary legislative choice that allows any change to take place sooner, because we have got to have this take place 3 months sooner. It gives it standalone focus and prevents it competing with any other high visibility issues like citizenship voting amendments on the November ballot. It relays a sense of urgency now, not 3 months later. So, why should we have election of judges? This is generally what the people that want to vote yes for this amendment say. Electing justices makes the judiciary more democratic, more accountable, and less controlled by the legal elite. This is an elitist system where there are a majority of attorneys on this commission. Now, this argument is a little far-fetched, in my opinion, because if that were the concern, they could have proposed a constitutional amendment that I don't think they would have gotten any objection to, that simply changed the nominating commission. Instead, the chair of the nominating commission shall be a non-lawyer. Then you've got more non-lawyers than lawyers. So this can't be the reason for the amendment, because the fix would have been much different. Should lawyers chosen by other lawyers decide, or should that power belong to the people? Now, this is just my personal opinion as a lawyer, but I don't know that I run a plumber deciding who's going to do my cardiac surgery. Lawyers are the ones that are in the courtroom all the time. They know whether these judges are good or know the law and act respectfully. Lawyers making the decision, I don't think is, and again, that could be fixed by just changing the makeup of the nominating commission. And the other thing is they will say is that lawyers control the nominating commission, and these lay people on the commission are just overrun by their opinions. I've been through the Supreme Court Nominating Commission. I've also chaired the Supreme Court Nominating Commission in Johnson County. And I can tell you that the non-lawyers members are very active. And what they generally do, and if you guys know anybody or ever want to be a non-lawyer member, I suggest you talk together and see if you can get appointed, because they will tell you it is an amazing job. In both the Supreme Court Nominating Commission and the Johnson County Nominating Commission, which I was part of, they team up for each applicant. So each applicant has a lawyer and a non-lawyer that are assigned to do their background. And that background includes talking to attorneys that have been on the same side as them, attorneys that have been on the opposite side of them, judges. They do an extensive background check, and they do it together as a team. And my experience has been these lay people are never shy to say what they feel about a particular applicant. The current system provides no accountability. Judges should be responsive to public concerns so that people should be able to review a judge if the judge's decision is contrary to the will of the people. And I suggest that's just absolutely counter to our Constitution and the whole point. 3 branches. Kansans should reclaim the right to vote for judges, which was taken away in 1958. They make it sound like somebody just jumped in and took it away. I mean, people voted, but they didn't want that system anymore. Elections will better align the courts with public values. And Kansas is an outlier. Most Supreme Courts elect their judges. And I have to say that in recent years, that's become true. There have been this kind of sweeping changes in states all over the country. The mother in me says, if Johnny jumps off a bridge, then do you jump off a bridge? But many Supreme Courts do elect their judges and justices, and we can look to them as an example. Because millions and millions of dollars are spent on these campaigns. And who's spending the money? Lawyers are donating money to these campaigns because they want to be on the side of the winning judge. So if you want lawyer influence, I think election of judges is going to give you pretty good lawyer influence. It's also going to give you a lot of corporate influence. But each of these states that elects judges, these campaigns cost them millions of dollars, often from outside the state. And here are just some, I'm just going to tell you quotes from different people. Sam Brownback, go along with us on this judicial selection issue. Let us change the way we select judges so we can get judges who will vote the way we want them to. That is the bottom line here. They're making no secret about it. Activist courts should not overrule the people of this state. No single judge should be allowed to change the will of the people with a stroke of a pen. He was responding to a district judge panel ruling on school finance and a Supreme Court gay marriage ruling. We need to have a court that's not activist and striking things down, because whatever we propose should be adhered to, should be granted. This is more recent. You know, you get to decide who your governor is. You get to decide who your legislature is, but nobody gets to decide other than those few who really gets to make it on the high court. If you get a nominee who takes the bench, we don't have any way to deal with the bad decisions that may come out of the decision process. So this way, we can vote them out of office if they make a bad decision, whatever the decision is. And I can tell you as a judge, and I think many lawyers and others will tell you, whenever you judge a judge, what you see in the paper about a ruling in a case, there's usually a whole lot more to it than you're seeing in the paper. I mean, most of the judges I know of in Kansas are very methodical. They are considering their decisions very cautiously. And of course, just like anything, the media or politicians will pick up on sound bites and make it sound like, oh my gosh, this is the worst judge that's ever lived. And the judge can't respond. Ethically, we can't respond to that kind of criticism. So in the main, it will be found that a power over a man's subsistence is a power over his will. That's what we're talking about. The power over who can be a judge and not be a judge based on election is a power over his will. What do the opponents say? The vote knows. The current system was established by a constitutional amendment back in '58. The people decided they wanted a merit system. What has changed? The Kansas Bar Association has no say who advances to the court. Extensive, transparent, and extensive review of all applicants. These applications are multiple pages long. You have to describe your net worth, everything about your finances, like I said, people you worked with, people you worked against, any ethical complaints that have ever been filed against you. It's a very extensive process. I doubt that you're going to get that process in an election. Judges are held accountable by rules of ethics and mandatory retention votes. There is a way you can get a bad judge out. But again, to remove a judge, and they had 4 judges in Iowa that were removed several years ago because of how they ruled on gay marriage. And it was a decision that came out right before the retention vote. And so they swept the whole Iowa Court of Appeals off the bench by that one decision. Yet every single court in the nation has followed that decision or has issued a similar decision since then. So we often are quick to fault when we haven't fully reviewed what the pros and cons are. Our founders said the judicial branch should be a check on the other two elected branches so the changing winds of political opinion would not usurp the rule of law. Kansas is an outlier, but if Johnny jumps off a bridge, I think that's probably mine. Legislature always has the option of maintaining the system and addressing, I can't spell, addressing the claim of elitism by pushing for a constitutional amendment to change the makeup of the nominating commission so it doesn't have a lawyer chair. That's all they have to do, but that's clearly never been the goal. If other states are an indication, big money will come to Kansas and push partisan positions. It will cost millions to win an election. I suggest to you that people that are studious of the law, good litigators who make great judges, are not going to give up their lucrative practices to run an election, which is going to cost them millions and millions more dollars. You're going to have a totally different look on the bench than you have now. George Will, I have to cite a conservative political analyst. Popularity makes no law invulnerable to invalidation. Americans accept the judicial supervision of their democracy. Judicial review of popular but possibly unconstitutional statutes because they know if the Constitution is truly to constitute the nation, it must trump majority preferences. So with that, I'm happy to open it up for any questions if I can talk for this minute. I went for 45, how was that?
Good.
Yeah,
That was marvelous. Thank you very much. And now, if everyone would take turns coming up to the microphone and keeping your questions succinct and to the point, it's open to discussion.
No, I'm concerned about the toxic effect of secret money.
You're about super PAC funding?
Yeah, secret money. So about 15 years ago, I was talking to a man who was a retired Kansas Supreme Court justice, and he was no friendly looking guy. So I asked him, I said, what job did you have before you were appointed to the Supreme Court? And he said, I worked for a firm that our entire caseload was defending corporations who had been sued. So do you think, I agree with your argument about elitism, but a person who works for a firm that whose entire caseload is defending corporations, I mean, that's about as elitist as you can get, as far as I can see.
Well, there are members of the Supreme Court and district court judges around the state that come from a wide variety of backgrounds. Some of them maybe have only been prosecutors before and haven't done any civil cases. But that's the point of the merit selection system. It looks at their entire record. You know, they may have, I think you're talking about Justice Ness, he may have done a lot of corporate work in his job in Salina County, but I think he also was a prosecutor for a short period of time after he got out of law school. They look at their entire background and they question them about those things, and they ask attorneys on the other side, do you think he's, you know, his position is based on ideology? Do you think he could ever rule the other way? And that's one of the questions that's asked. So you don't necessarily always get somebody that has every level of experience, but you try to get somebody that is a good ethical lawyer, that has good research skills, and good analytical skills. I'm so sorry. That sounded awful. Before you select them. So those things are questioned. I don't think the nominating commission wants necessarily somebody that's only going to be out for one particular side. But most good attorneys and scholarly attorneys, you know, you have to practice law in some area. That's the firm you've selected to go with, and because you've selected that firm doesn't necessarily mean that should exclude you from ever being a judge if you're a good and fair and impartial attorney.
So I just wanted you to say how you are selected, because it's a different process for the Court of Appeals, right? But it's still not elected.
Right. So during Governor Brownback's term, The Kansas Board of Appeals used to be selected by the same nominating commission that selects the Kansas Supreme Court. And that was done by statute. But, and we had a professional qualifications commission that every judge, this commission did a study of every single judge and put their rankings or ratings on for everybody to see. You know, people that appeared before them, other attorneys said that they know the law well, or I mean, they had an actual rating on each of these things. And the first thing the Brownback administration did was defund that commission. And then they changed the selection of Court of Appeals judges from what we call federal model right. The governor makes the selection, the Senate confirms, and then they're subject to retention, so it's not lifetime selection. But, so that's how the Kansas Court of Appeals is selected. That's because it's statutory, but I can tell you that although Governor Brownback and Governor Collier did not do this, Governor Kelly has made up her own nominating commission. And so she requires all applicants go through this nominating commission. So she just doesn't cherry pick somebody who she thinks should be a judge. They have to go through this process and make it through the process just like we do for the Supreme Court nominating commission. That is just entirely her personal decision. The statute does not require you do that.
Good evening, I'm Matthew. Recently moved back to Kansas, back to the area. I'm registered as an undeclared, so I'm not able to vote in the primaries, or is there a way? You can't answer maybe legally.
Maybe a link can answer that.
Yeah, I think everyone, because there's a constitutional amendment, I think everybody can vote in this primary.
Oh, okay.
But just for that issue.
Just for that issue. Thanks.
Hello, I'm Robin Hughes. My question is, under the current amendment option, are there any precedent put in place for how someone could be able to be on the ballot? Are there rules?
Really, there aren't. It's all going to be set up by, I mean, there's a staggered system so that judges that are on the court, it'll be when their term is up in a staggered way that they'll be subject to election, if that's what you mean.
That is fine.
Whether it's partisan or nonpartisan is not part of the amendment. That'll be something that'll be decided by the legislature.
Second piece of that. So if someone decides to run for the court, currently there are rules in place. You have to be at least 30 years old, you have to be an attorney, you know, all of those things. Will those continue to be in place?
I think those will, I don't know that those will change at all.
Okay, that's what I wondered.
They still have to meet those minimum qualifications.
I have Ricolas for you.
Pardon?
I have Ricolas for you.
Oh, okay, great. I have some of these cherry ones, but they're obviously not doing the children.
These are So that's some other meat, but we're along. And thank you for being here. This is amazing. So a couple of questions. Since these are all attorneys or lawyers, I learned that there's a difference.
Who are all attorneys or lawyers?
Or not all, but the nominating commission.
Right.
Is that there are lawyers on the commission. So, since they probably know the other people, is there a recusal process?
There is.
Okay.
There is. If it's a partner of the person that's there, they'll recuse themselves from that decision. It doesn't happen very frequently, but it has happened.
Number two, and I should look it up, but so the non-lawyer person, you know, those of us who are Perry-Mason wannabes, what is the process for presenting that desire to the governor?
You just contact the governor's office that you'd be interested in being appointed for the next opening on the commission, and it's based, as was said by Justice Breyer, it's based on your congressional district, so there's a smattering throughout the state, so based on your congressional district, this sheet tells you who's, like, for Lawrence, Diana Oaks is the non-lawyer member and what her term is. For the 2nd Congressional District, it's Frances Warren Graves and what her term is. So you can look based on your judicial district, see who's in there, see what their term is, and ask to be appointed. Okay?
I'll ask another question, and I should identify myself. I'm Ann Zimmerman, and I'm an attorney, and I'm also the vice president of the Legal Room Voters. But I guess it's not so much a question, but a couple of things. We used to have a member from Salina who was the lay person for the big 1st district. It was Jenna Yankee, and she was an English professor at Kansas Wesleyan University. And she told us about her experience and said that she just kind of chuckled when they said that the lawyers were lording it over the lay people, because she said it was all very respectful. They were all assigned their jobs to investigate, and that they all brought their information back and had very recent discussions that, you know, she as a college professor was not groveling before the attorneys. They were holding their own, she said, the lay people. I guess the other thing I want to mention is that you and I guys have a friend, Patty McDick, who is a judge in Hutchinson, and that's an elected district. And she said that she had to get contributions to run for office, and when somebody who had given her a contribution was appearing before her, she could sort of feel the pull that she should really decide for that person. She had to really fight that feeling that when she got it in court to ensure that she met her own standards of ethics to not decide in favor of the people who donated to her campaign.
And would you want to be a litigant walking in front of a judge trying to decide if your lawyer had contributed to this judge or to the judge's opponent? And I think judges throughout the state, they do just what Judge Patty McDick did, and that is they are very conscious of the fact that they have to ignore that. But the appearance is the point here that you can't get past.
Can you talk a little bit about states that have gone this way, and what are the real life impacts in some of those states?
Well, there was a famous case out of West Virginia, I may be getting this wrong, where the huge oil and gas case, so they actually, all the oil and gas companies pitched in money to elect a Supreme Court justice that was from that, that was a part of that whole area of law, and it changed the decision of the Supreme Court on a pretty significant issue. So I think we're fooling ourselves when we think that corporations that have been big money at stake in a lawsuit or in a series of lawsuits aren't going to try to get in judges. As I said, the proponents they're not shy about saying, we want to get judges in who will rule the way we want them to rule. I mean, it's not a secret, I don't think, because I hear them say it again and again and again.
Sounds like we're done.
We're done.
Thank you very much.
I'm so